Versus George Mason University, and Ms. Gurecki, we'll hear from you.
Good morning, and may it please the court. My name is Kara Guricki, and I represent Dr. Todd Kashdan, the appellant and plaintiff below. This appeal concerns the district court's Federal Rule 12b6 dismissal of Dr. Kashdan's case in its entirety with prejudice. The first issue I would like to address is whether Dr. Kashdan adequately pled a plausible inference of gender bias in support of his Title IX erroneous outcome claim. Dr. Kashdan's Title IX erroneous outcome claim should not have been dismissed. When viewing the facts alleged in the complaint in the light most favorable to Dr. Kashdan, it can plausibly be inferred that the key decision makers in Dr. Kashdan's Title IX proceeding wrongly disciplined him because he is male. Dr. Kashdan's allegations fall within the ambit of Title IX cases nationwide in which federal courts have permitted plaintiffs to proceed.
So which paragraphs in your complaint do you say make that allegation?
Of gender bias, Your Honor?
Yeah, that the erroneous outcome claim is determined on the basis of his male gender and that that's a but-for cause of his discipline. Because in order to survive the motion to dismiss, obviously you have to make allegations that plead what the law requires. So that's what I'm asking. What are your best paragraphs in the complaint that do that?
Yes, Your Honor. In response to that question, there are allegations about the Title IX investigator named Megan Simmons, who was removed from Dr. Kashdan's case for gender bias. That's paragraph A143. Also, paragraph A44 of the complaint, regarding the sole adjudicator or decision maker in his Title IX proceeding, we have Dr. Jennifer Hammett, the Title IX coordinator. Evidence of her gender bias is located at A46, also A331 and 332, A79, A296, A89 to 90. Also, Dr. Hammett credited the female complainant's allegations over Dr. Kashdan's, even though there was compelling evidence that refuted the assertion that he engaged in sexual harassment. Those allegations are located at A95 to 96, A99 to 100, also A70 to A72, A74, A81, also A82 and A83.
You're given pages, and there's a lot of paragraphs on each page. So maybe when you come up at rebuttal, you can give us some specific paragraphs.
Yes, Your Honor, I'd be happy to. As alleged in the complaint, Dr. Jennifer Hammett, and as previously mentioned, was the sole decision maker in Dr. Kashdan's Title IX proceeding, meaning any evidence of Dr. Hammett's gender bias is particularly probative. That's under Doe versus Marymount University. Dr. Hammett has publicly expressed views which reflect outdated and stereotypical views of gender. She also had written findings in Dr. Kashdan's case that reflect stereotypical views of gender. Her role as the decision maker in Title IX proceedings for George Mason University conflicted with her role as the enforcer of Title IX on the campus, particularly at a time when Mason was under public scrutiny for the mishandling of Title IX complaints of female students. Dr. Hammett herself was criticized in the student newspaper months before Dr. Kashdan's Title IX proceeding. She was criticized for the mishandling of a female student's sexual harassment allegations against a male student. The second decision maker involved in Dr. Kashdan's Title IX proceeding was Dr. Julian Williams, who handled his appeal. Mr. Williams made public statements reflecting a pro-female approach to Title IX complaints. That is page A30.
You know, all of these references you're talking to is a disagreement with the school's decision, and maybe even a misguided decision that the school has traditional or outdated views of gender. but is there a difference between the substance of the decision-making and the treatment of the case? In other words, disciplining the professor because he had different views is quite different than disciplining the professor because he was male. And I'm not sure, it gets a little bit back to Judge Agee's question, is do we have any alleged evidence that the decision was made because he was a male and not because of the views he held or the practices he followed in his class? I think this, if you read fairly the entirety of the complaint, it reflects the school's position that he went beyond the bounds of proper educational practices and got involved into the personal lives and practices of students and himself, contrary to the policy of the university. And the question that we really have to probe is whether the school made the decision because he was male. And I'm not, maybe you could focus on that.
Yes, Your Honor. The views that I was referring to in my prior argument actually referred to the views of Dr. Hammett and Mr. Williams.
I understand, and you say those are decision makers, and they had obsolete views of gender or views of gender different from the professors. But the question I have is that hardly states that the decision was made because he was male.
Your Honor, the views of the decision makers here did not necessarily differ from Dr. Cashdan's. Their views concerning the position of the female students who complained about Dr. Cashdan's alleged misconduct, the decision makers' views about the female complainants differed
where
from
would we be if the students, the female students, brought an action against the university based on Cashdan's conduct and statements in the classroom and outside the classroom with students? They would say they were interfered with their ability to learn because they were females and they were treated as females by the professor and were being baited and provoked and stimulated sexually, creating a hostile work environment. That would be their claim, wouldn't it? The
Yes.
female students?
Yes, Your Honor, but
And that's what the university looked at and said, we can't have that in our classroom. I mean, he was dismissed because of a Title IX. The school thought he violated Title IX, and now he's coming back and saying the school violated Title IX. But it seems to me your argument, and maybe I'm wrong on this, but it seems to me your argument is that he had more progressive views of gender and sex and sexual practices than did the school, and that disagreement led to his firing, as opposed to the fact that he was not firing, he was disciplined. His discipline was based on the fact he was a male, and I think there's a significant difference between those two things.
Yes, Your Honor. To answer your question, I do not believe that the complainants 1 through 4, would succeed on a case in an action against George Mason because Dr. Cashdan...
Well, they may not, but that's what the school concluded. And we don't have to decide whether the school was correct, but that was what the school was addressing. And when you have female students complaining about practices that I think many people would wonder whether they're appropriate in the classroom, things that were being stated, inquiries of students' own personal sexual practices, how many times they've been to bed with somebody, he explaining his own sexual conduct and events. Aren't these legitimate questions that ought to be raised about, is that the appropriate practice in a classroom, especially when the female students are complaining and don't believe that's appropriate?
No, Your Honor. The question raised by the school was not about appropriate or inappropriate practices. It was whether or not Dr. Cashdan was a sexual harasser under the school's Title IX policy.
What's the difference?
And there is a difference.
I mean, if he created the environment about which the women were complaining, hostile female environment, or very sexually laden discussions, as opposed to more objective discussions that didn't involve the professor himself and the students themselves. I think that was their problem, and the question is whether they're right or wrong. That looks like the real reason they gave, didn't it? I don't know what other reason they gave.
Your Honor, there was compelling evidence submitted by Dr. Kashdan to the decision makers in his case that none of the complainants suffered a denial of access to their education or educational opportunities. Complainants 1 and 2, their allegations relating to Course A and Course B.
Maybe this university got that wrong, but that's what they believed based on the complaints. And a casual observer looking at this would be certainly worried about whether the classroom and the relationship between professor and students was an appropriate one under Title IX. And I think that's where the school came from.
There's a very different view, Your Honor, between whether or not behavior is appropriate or whether or not a faculty member violates Title IX. The Course A and Course B examples that Dr. Kashdan gave were discussed years prior to the complaints being brought. The students themselves, complainants 1 and complainants 2, gave Dr. Kashdan rave reviews for those courses in their student evaluations.
Isn't this kind of a distinction in some of the, between this case and some of the cases you cite, is everything we've been talking about so far is the women and the professor pretty much agree on the facts of what happened. He did say it in a certain context, etc. They just disagree about whether it rises to the level of harassment or whether he thinks the women welcomed these comments. They say it was pressure from a professor to get a good grade, you had to participate. But both parties pretty much agree that these things happened. It's not he said, she said, like a lot of the cases that are cited in this area.
Dr. Kashdan did acknowledge certain facts that they occurred, but he denied engaging in any sexual or gender-based harassment.
Right, he disagrees on how it's characterized, but he admits it happened.
No, because, for instance, his examples in Course A and Course B were given to the entire class. There was no language directed at students based on their gender.
Again, the parties agree basically what happened. That's what I hear you saying. I'm just pointing out that's a distinction, and so many of these cases are he said, she said types of cases. She says it happens, he said it didn't, and the allegations of those complaints say we have reason to think the administrators took the women's word and disregarded all of the male testimony, right? There's some sort of linkage to allege a but-for cause here, and that's the sort of evidence that we're trying to find in your complaint.
Well, there are a number of cases in which Title IX respondents that have been accused of sexual misconduct have arguably admitted certain of the allegations. So Doe versus Baum was one of them, 903 F. 3rd 575. Doe versus Rector and Visitors of George Mason, 149 F. sub 3rd 602. And Norris versus University of Colorado, 362 F. sub 1001. In those cases, at the motion to dismiss stage, the courts held that even though the respondents had admitted certain facts had occurred, that the claims could proceed to discovery because the respondent had denied engaging in sexual misconduct. There was a nuanced distinction where perhaps in Norris, for instance, he admitted to pinning a woman's arms over her head, which was part of the underlying charge, but not to engaging in sexual misconduct.
You're running sort of short on time here. Do you want to say something about your selective enforcement claim?
Yes, in light of the court's Shepard decision, I do believe a similar similarly situated comparator is necessary, so we will not be arguing that Dr. Cashdan's complaint against complainant 4 alleges a selective enforcement claim. And we do believe that under the case law, you can allege selective enforcement upon information and belief when the records are exclusively in possession of the university.
Is that it? You've
Yes.
got some rebuttal.
Thank
Thank you,
you.
Ms. Gurecki. Mr. Ferguson?
Good morning, Your Honors, and may it please the Court. Andrew Ferguson on behalf of the university. I'm joined by Kevin Gallagher, Deputy Solicitor General. This Court should affirm the judgment of dismissal. First, to prevail on his Title IX claim, Dr. Caston must show that his sex was the but-for cause of the university's decision to sanction him. His allegations of supposed anti-male bias fall woefully short of plausibly pleading that the university would not have sanctioned him except for his sex. And I would like to address very briefly the particular allegations that my friend on the other side has raised that show, or that purport to show the anti-male bias. I want to begin with the erroneous outcome problem. I agree with what I understand to be the panel's impulse here, that erroneous outcome itself doesn't tell the court anything about whether there was anti-male bias, and anti-male bias after Shepard has to be the but-for cause for the decision. And I think that's made obvious for the reason that even if a university correctly applied an internal harassment policy, but the reason that they applied the internal harassment policy was because they were discriminating against the target of the harassment policy on the basis of sex, there would still be a Title IX claim. The erroneous outcome itself just doesn't lend itself to any particular inference one way or the other, which is why this court explained in Shepard it's insufficient to show procedural anomalies or a disagreement over what the facts are or how to read the facts. A plaintiff in a Title IX case has to show evidence of anti-male bias. The evidence that my friend on the other side has pointed to are some public statements from 2 university administrators who are tasked with enforcing Title IX that express the view that A, it is important to enforce Title IX, and B, that if a Title IX is not vigorously enforced, students might not feel safe. I just don't think that anything in those statements, which are found at pages 331 to 333 of the Joint Appendix, can be remotely read to suggest an inference of anti-male bias. And certainly the plaintiff is entitled to every reasonable inference from his allegations, but not to any inference whatsoever. And none of the statements that are at issue here suggest anti-male bias. And I want to briefly address the due process claim before moving on. The court has held now repeatedly that short of a termination, the only way that some sort of internal transfer or discipline can qualify as a due process violation is if it results in the employee, quote, being effectively excluded from one's trade or calling, as by being thrown out on the street, end quote. I think the minor temporary adjustments to Dr. Cashton's employment status simply don't qualify as being thrown out on the street. And this court has been quite adamant, both in Hall and in Ridpath, that the test was the demotion effectively a termination? This was not effectively a termination. He remains a tenured professor of psychology. He's been publishing profusely during the period that this appeal has been pending in this court. I just don't think we can fairly describe this as having been thrown out on the street.
So is the short-term aspect of the discipline what distinguishes this case? Because as I understand the plaintiff's argument here, it's that I was a high-level PhD professor. I only dealt with graduate students, and now I'm back to teaching Psych 101, and that's a significant change in my field. Is the temporary nature of that the main distinguishing factor?
It certainly cuts in favor of the university, Judge Agee. I don't think it's the main distinguishing factor. In fact, even if the restrictions weren't temporary, I would probably be making the same argument. I'll just use Ridpath as the counterexample here. In that case, the plaintiff was removed entirely from one department, ceased to exercise any of the functions of his previous job, and was shipped off to a different side of the university. And the court held, look, like that effectively was a termination from his previous position. Admittedly, he was reassigned within the same entity, but he doesn't operate any of the faculties of his previous position. That just isn't true here. Professor Cashton remained a tenured professor of psychology with teaching and research obligations, and he continued to teach and research during the period that the sanctions were in effect. And of course, accepting the disaffiliation sanctions, the general probationary period regarding his relationship with grad students has expired during the pendency of this appeal, so he's back to that in any event. But no, I think that the temporary nature cuts in favor of the university, but I do not think that the university's position would fall if the adjustments were permanent. And unless the court has additional questions, the university is comfortable resting on its briefs for the remaining arguments.
All right. Thank you, Mr. Ferguson. Mrs. Gurecki?
I'd briefly like to address the due process arguments that were just raised. Most of the points made related to things that are not in the record, that Dr. Kashdan is publishing prolifically. He's now working with graduate students. Those facts are not in the record. We would have been happy to have Dr. Kashdan give testimony on this issue. What I can say is that his disaffiliation from the clinical psychology program is 5 to 6 years at a minimum, and he is still not teaching within that program, not working with grad students from that program, not involved in any of the governance he was previously involved in. Also, he's not currently working with graduate students. So our view is that he did suffer a significant demotion and a perilous detour in his career because he had founded and chosen to affiliate with the clinical psychology program and has been unable to do that.
Am I correct that his compensation was not reduced?
His base salary was not reduced, but because of the restrictions placed on him, he is not entitled to merit-based pay increases as well as standard increases in his salary.
But were other than the disaffiliation part, all of the other sanctions, if that's the correct word, were short-term? Is that correct?
No, Your Honor. The graduate student sanction that prohibited from working with graduate students was supposed to end in 2021, but it did not because the clinical psychology program disaffiliation overrode that, precluding him from working with graduate students for a lengthier period of time. He has alleged that graduate students are the life force of his research and his success is due to them, and that has not changed. He's not able to work with graduate students in any program. And I'd like to also add that Dr. Kashdan's chosen trade or calling was not just a professor and not just a professor of psychology. It was a professor affiliated with the clinical psychology program. And to him, not being able to rely on the life force of his research is a significant and perilous detour in his career path. And I yield the rest of my time.
All right, thank you.
Thank you.
We'll come down and greet counsel, and then we'll proceed on to the next case. right, the next case we're going to hear this morning is United States versus Miller. And Ms. Powell, whenever you're ready, we'll hear from you.
In the United States and the procedural and substantive unreasonableness of the district court's major upward variance sentence of 6 years in prison. This court ordered supplemental briefing on the intervening decision, United States v. Campbell, and its application to North Carolina drug offenses involving delivery. Miller has also asked the court to assign a different judge in any further proceedings. Beginning with Miller's challenge to his conviction under Rehafe, even if plain error applies, which Miller contends it does not, he has met the standard under Greer v. United States. The errors are plain, and Miller has shown that the errors affected his substantial rights.
Let's identify the error.
I will, Your Honor.
I must say, I read the entire proceedings, and I thought the court explained very well to Mr. Miller the elements of the offense, including the Rehafe, saying in two different ways. First, that the prior crime had to be have a sentence of at least 1 year, and he says, in other words, a felony, and went on to explain that he had to know that status. And I don't understand where the Rehafe error is.
Of course. It is our view that as a matter of plain English and grammar, what the court said at the guilty plea, but first what the government's indictment said, or should, I guess, since you
Well, let's
addressed...
stick with what he pled guilty,
Yes.
and the court advised him of the elements of the offense before he pled guilty.
Yes.
And
the
so the
elements were-
question is, what did the court misstate?
Yes. In the sentence, there was a subject, there was, in other words...
Just read that sentence. What is it?
The government would be required to prove beyond a reasonable doubt that you were previously convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year. In other words, comma, a felony offense. And
What's wrong with that?
you knew of your status as a convicted felon. The first part, in other words, as we noted in briefing, is commonly understood to modify, rename, clarify what precedes it.
It's just explaining that a conviction for a sentence exceeding 1 year is a felony. It says, in other words, a felony. And that happens to be the way the federal law defines a felony.
That is true. If both of them are equal, then which
What's the problem?
position
They're
it
both the
follows
same.
in other words is irrelevant.
Other
But-
words is saying it's the same thing. He's talking to somebody, he says, have you been convicted of a crime in the past which was subject to 1 year, or in other words, a felony?
Yes.
And the guy says, yeah, I was.
Yes, and our view is, as we showed in numerous examples of indictments over all the 94 districts.
Except we're talking
federal
about a
districts.
guilty plea, and we're talking about the advice he was given, and that he pled guilty after being given that advice.
Okay.
Yeah.
Yes.
So do you have any other rehafe argument besides that?
Yes.
Why don't you make it?
Okay. But if I could finish your question quickly. In other words, as the cases we cited show, grammatically modifies what precedes it, redefines, clarifies what precedes it. We have the cases cited in our brief. In
All
other
right,
words,
let's just say, agree with you. Now, what's wrong with that?
it's saying this term, complex legal term, a crime punishable by imprisonment for a term exceeding 1 year, means felony.
Right, and that's
It's not
exactly what the
saying-
federal law says.
Under federal law, that's what a felony
He's
is.
explaining the federal law. He's explaining the elements of the offense, 922G.
Yes, I
And he's
understand.
saying, he's giving you the elements, and the federal law defines it that way. Now, I don't understand what the
The
problem is.
word felony does not appear in 922G anywhere. It is a shorthand, easy, useful way to refer
So
to a
he's
very
explaining,
long
he's
thing.
giving this man, he's saying, I'm going to call this a felony.
He
And then he says,
redefined the
you
term.
had a gun with a felony. And of course, every opinion we do,
Yes.
possession of a gun by a felon, a convicted felon, is the violation.
Yes.
But that's because the federal law defines the word felony to be exactly that.
That's true, but North Carolina does not
We're
define a felony
not under North
that way.
Carolina law. We're
No,
under,
but we're asking about rehafe, about what he
Rehafe.
might have understood.
ma'am, we're talking about a 922G element. And that is a federal element. And the federal element is that it needs to have an offense committed for exceeding 1 year, in other words, a felony. And that's what the court told him.
Yes,
And you say that's wrong.
I'm not addressing the indictment problem.
That's
But
an indictment. This is
I
a
don't- but
plea
there is
agreement.
language in the indictment that is identical to what the court said, and it is always in the reverse. It is a felony offense, comma, in other words, a crime punishable for more than 1 year in prison. It
I
is
think we
never,
understand that part of your argument. It's up to you. You can argue as long as you want, but you might want to consider moving on to something else.
okay, thank you, Your Honor. The second error is the indictment was erroneous. Again, it told him that he was guilty under 922 as long as he knew of his state prior felony offense. And I realize these terms are exchanged, as the court has said recently in Hayward and United States v. Baronet. The term felony is imprecise and overbroad. It is not the legal term.
It's a legal term.
A
It's
crime
used in the federal
punishable,
statutes.
a crime punishable by more than 1 year in prison, et cetera, et cetera. And even
And the
Hayward
federal statutes
recognized,
define a felony.
yes, as more than 1 year.
And they define it as a crime exceeding 1 year.
And that word is not used in 922G or in
Well,
920A.
the Supreme Court used it in Greer because they said individuals who are convicted felons ordinarily know that they are convicted felons.
That is correct. And it is a convenient shorthand, as Hayward and
Well,
others have
If the Supreme
recognized.
Court uses it, don't you think we might want to follow what they say?
That they were not deciding what constituted that element. They were talking about it usefully, quickly, in the
You know,
context
the nice
of
thing about
other
the
things.
instruction the district court gave is he told them both. And he says they're equivalent, which is exactly correct.
But they are not equivalent. A felony under a conviction under 920 is state law, and state law defines a felony not in terms of any
I think you're wrong on
imprisonment.
that, ma'am, because state laws will call something a misdemeanor. We identify a felony under federal law based on the term, and it has to exceed 1 year. So if a state statute says you can be guilty and serve a sentence up to 3 years, and it's a misdemeanor, we call it a felony for purposes of 922G.
Yes, I understand that.
Okay, well, you keep
That
going back
word,
to say the state
that
law.
term is nowhere in the statute, and it is, as Jerome v.
Okay, why don't you
U.S.
move on?
said, Burgess v. U.S., Hayward and Baronet noticed, it's overbroad, it's imprecise. It is not the equivalent. May I continue?
Please.
Under rehafe, it is not enough to show that he was a convicted felon. Under any name, state law, or federal offense, a convicted felon is not the same thing, as numerous cases have said. What matters is if the person knew that that felony offense faced the possibility of more than 1 year in prison for him personally. This is not merely semantic or quibbling with words. For decades, it has been the case in North Carolina, as we showed in briefing, that more than 60% of all felony quote-unquote convictions in North Carolina receive sentences of probation, which means under state law, it's a community or intermediate punishment.
Federal law says it has to be punishable, not what he received.
Yes, I'm not
Not
arguing
punishable.
about whether or not it qualifies as a
This
predicate.
man received a sentence exceeding 1 year, and he was told he was received a sentence exceeding 1 year.
Yes. In the context of rehafe, which I'm getting to the factual basis, that matters. So defendants, all 60% of North Carolina, yes, ma'am?
Mr. Miller had an attorney, didn't he?
He had an appointed attorney.
Who he said he was satisfied with his attorney's assistance.
Correct.
And his attorney had explained to him the offense and what it required and what he was pleading guilty to.
He did. He also, the plea agreement never gave the actual elements of the offense. It said they've been explained to him by his attorney. So nowhere on the record is there the actual correct elements of the 922G offense. So looking at the sufficiency of the factual basis, whether or not a crime qualifies as a predicate is relevant, and significantly the characteristics of the felonies, the prior convictions, the characteristics of the individual person. As I mentioned, for decades in North Carolina, it has been the case that more than 60% of North Carolina felons receive what by law must be totally suspended, intermediate or community punishment.
So what difference does that make in this context?
When thinking about the rehafe knowledge of status, whether or not the government's factual basis proved the rehafe element, many cases today, it's been nearly 4 years since rehafe was decided, and there are numerous cases that illustrate.
This is not a case of proof. This is a case of explaining to Mr. Miller that the elements of the crime before he chose to plead, and explaining that he had to have committed an offense that had a sentence punishable exceeding 1 year, in other words, a felony. That's what the court told him. And he said, I understand that, and I plead guilty.
We disagree on what he was told. We think the language used in the sources we've cited, none of them, the Middle District of North Carolina is unique. And the statements of the judge under plain English clarified and changed the meaning of the first term.
Do you want to talk about any of the sentencing before you sit down?
I would like to quickly go through the factual basis part of the argument. The mens rea element was insufficient.
So you don't want to talk about the sentencing today?
No, I would love to. If the court would be interested in talking about Campbell, I would like the supplemental briefing. I'm happy to.
Well, it's your argument. You have a couple of minutes left, and I would direct it to where you think you have the best, strongest arguments to make.
Well, I actually do think, as Hayward and Barnett recognized, Greer refused to allow a legal presumption that when a person has a felony conviction, if we want to call it that, then they must also have the mens rea under rehafe. There is no legal presumption, and recent cases in this court have recognized, unless we close the door, unless every felon legally, as a matter of law, has the rehafe element of knowledge, as long as he has a felony conviction, I wanted to emphasize that Mr. Miller is that case. He is the rare paradigm. If there's going to be an exception for when a person actually has a felony offense in their prior conviction, but yet meets plain error under rehafe, it is Mr. Miller. He never spent a day in his life in prison before the federal convictions. He remained out on release throughout the federal charges and had no violations of any kind. He received only one suspended sentence. He served 12 months of probation.
We know all that. If you want to
Okay.
say something about Campbell and Groves, I suggest you move
Yes.
on to that.
Thank you. Excuse me. Turning to the challenge, particularly under Campbell, to the procedural and substantive unreasonableness. Miller demonstrated that the North Carolina delivery offense punishes conduct that is broader than the federal drug distribution equivalent, 841A. It punishes conduct covered in 841 and 846, the inchoate offense under federal law. The North Carolina conviction for delivery includes, as State v. Beam says, the attempted delivery offense because of the attempted transfer language. The government has asked the court to interpret attempted transfer in the same way that other federal and state jurisdictions, some have interpreted it, and that is not correct.
Well, a distinguishing factor in Groves was that to read it as you would project, that would have rendered Section 846 superfluous. And it looks like to me Section 90-98 of the North Carolina Code is basically a carbon copy of Section 846 in the U.S. Code. So why wouldn't the same argument apply here?
It can't apply here because
Well, why not?
Because of the case law that we've cited that says under North Carolina law, when there's attempted conduct in the definition of a statute, the courts construe it as the legislature's unequivocal attempt to put the inchoate offense attempt and punish it as seriously as the completed offense. And that is what they've done. The State v. Beam took that settled principle and applied it to delivery. I've also shown there is not one case involving charges under 9098 for attempted delivery. That's because, as the state case law makes clear, that attempted transfer is the legislature's intent to embed the inchoate offense in the substantive crime.
Okay, thank you. You have some rebuttal.
Thank you.
Yeah. All right. Ms. Reese?
Good morning, and may it please the court. Morgan Reese on behalf of the United States from the Middle District of North Carolina. Your Honor, there are several issues in this case. I am going to turn first to the issue that comprised most of my opposing counsel's discussion this morning. However, if this court wishes to turn to another issue, please inquire, and I will be happy to turn to it at that time. So turning first to the issue that we've discussed this morning, which is the sufficiency of the factual basis. And plainly stated, there is no error here. The factual basis was sufficient, and the district court was subjectively satisfied that the defendant here, Mr. Miller, knew he'd been convicted of a crime punishable by a term exceeding 1 year. Opposing counsel in briefing suggested some other standards of review, but the government suggests, as I think this court has acknowledged, the standard here is plain error. So the inquiry for this court is first whether, of course, there is an error, and simply put, as I've said, there is not. What this court can review is the evidence in the record. So we have the written factual basis provided by the government, as well as then the plea colloquy conducted by the district court. So turning first to the factual basis itself, the language in the factual basis, as found in the joint appendix at 107 through 114, provides what the defendant was convicted of in state court. It provides that he was convicted of the sell or deliver the Schedule II controlled substance. His sentence was 10 to 25 months. That was suspended for a term of probation for 12 months. And then he also signed a plea transcript in which he indicated he understood that the maximum possible punishment for his offenses were 47 and 39 months, because there was another conviction for the flee to elude on the same judgment. So right there, right off the bat, the written factual basis is sufficient. But then as this court has referred to, the Rule 11 hearing, in which he was represented by counsel, and he advised that he was satisfied with his counsel's representation and had no inquiries. The plea colloquy tells us, first, the defense attorney advised the court the defendant understood the charges, the plea was knowing and voluntary.
Second, the defendant himself responded to questions from the court that he had first reviewed the indictment. Second, he understood the charges. He was fully satisfied with the representation of his attorney, and he was pleading guilty because he was, in fact, guilty. All of these statements are afforded the presumption of truthfulness, and that's the standard this court should apply when evaluating a Rule 11 hearing. As this court has pointed out at the change of plea hearing, the district court then directly advised the defendant of the crime, of the elements of a 922G1 offense. And the language that's relevant here that this court has pointed out is that the court says convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year. In other words, a felony offense. That is the element that's at issue. The defendant was explicitly advised of that. And then the court went on to say and advise of the element that the defendant had knowledge of that felony conviction. And that was on page 132 through 133 of the record. Your Honor, here there simply was no error in the factual basis. There was no error in the plea colloquy by the district court. All of the evidence suggests that the district court was subjectively satisfied and that the defendant simply cannot prove an error that is plain under the plain error review standard. Your Honors, I will be happy to turn to any questions regarding any of the other applications of the guidelines. I do want to briefly address one point that opposing counsel made regarding the Beam case for the controlled substance offense analysis. As this court has pointed out, Groves stood for the proposition that the attempt offense, which is punished separately federally, would have been rendered superfluous by an alternate reading as suggested in Campbell. The North Carolina statutes are the exact same. Now, certainly Beam discusses this action of attempted transfer of drugs, and if the court reads that, the language that the Court of Appeals, the North Carolina Court of Appeals uses, is consistent with this understanding of an attempted transfer, not an attempted delivery. So that case in and of itself doesn't invalidate this court applying the logic of Groves.
I did want to ask about that because it does seem most of the North Carolina cases talk about it in those terms, right? An attempted delivery is or attempted transfer is a completed delivery under North Carolina law. That's CAR in other cases. Beam says an attempted delivery is enough, is a delivery. They don't explicitly talk about the attempt statute. They don't reconcile the two, but we're supposed to be trying to guess what North Carolina courts would do if we don't have clear guidance. And I wanted to hear your response on how, putting all this together, how should we guess what North Carolina would do?
Certainly, Your Honor. Well, I think first of all, we have to look to the structure of the statutes. So the statutes, much like the federal ones, do criminalize attempts separately. So I will start off there. Beam uses that language, but when you dive into the facts of Beam, you can see that that is the concept of an attempted transfer. So there is an arrangement between an undercover officer and the defendant in that case, and then they call for the takedown right before the drugs are actually physically handed off. So the concept of attempted transfer that we've listed and explained in our brief, which is consistent with this court's reasoning in Groves, involves the actual drugs, but it's something preventing them from being transferred. And so that's really what Beam discusses. The court in Beam, the North Carolina Court of Appeals, not the Supreme Court in Beam, did discuss that, and they substituted the word delivery. That doesn't invalidate this court applying the Groves logic here, because the conduct underlying that is consistent, as I said, with attempted transfer. And to Groves's point, if we have this attempt statute, but then we also have the substitute statute, reading it contrary to that would render the attempt statute superfluous, which is really contradictory to how we're intended to read
Maybe
statutes.
not entirely, right? Because attempt statute would still apply to manufacture and other parts of that statute. But that is that's consistent with the reasoning of Groves, and this, maybe the question is just whether this statutory scheme looks more like Groves or Campbell.
Yes, Your Honor, and certainly in the Campbell briefing, the parties agreed in that instance that the inchoate attempt, the analysis really wasn't quite done in the Campbell case, that maybe it was done in the Groves case. So I don't know that we can apply any sort of logic from Campbell that would necessarily invalidate our scheme in North Carolina. So I would just encourage the court, when considering this question of Beam, to consider the intent of the court when applying the statutes, which was that in that instance, that was very clearly an attempted transfer, which is consistent with North Carolina's definition of delivery. I would also put forth to this court that perhaps this court may not even need to address that question, because if we consider that this was a Class G conviction for a sale of a controlled substance, this court can consider the analysis under sale, and there are cases such as Chevalier which demonstrate that attempted sale is punished in North Carolina. So I would...
But attempted sale, North Carolina isn't a sale, just a delivery with money?
Sale, yes, Your Honor, the definition of sale in North Carolina is delivery of something for receipt of value. So yes, absolutely, absolutely.
So you could
true,
have an
Your Honor.
attempted transfer for cash.
That's right, Your Honor. And so I do think that that may be a way that this court might not even necessarily need to reach the issue of delivery, but I do still think that even if this court does reach that issue, Beam doesn't invalidate the Groves reasoning, and I do think that's still applicable here based upon the substantive nature of the Beam case. Unless this court has any further questions on any of the issues.
With respect to the criminal history, do I understand your position that we're going to have to send it back on that for resentencing?
Yes, Your Honor, that is the submission we've offered this court. The government has determined there was an error based upon the fact that it appears the probation, it was a warrant rather than a probation violation. It was an order for arrest for missing a court appearance as opposed to a probation violation, which I think under the guidelines definition of what can qualify would necessitate a remand for just that limited issue.
Well, might that also affect the variance?
Well, yes, certainly.
The whole resentencing, the judge will have to recalculate and resentence.
Yes, Your Honor. Yes, Your Honor. I think the court's analysis there is absolutely true, and we would suggest that a remand is appropriate for that purpose.
All right, thank you.
Thank you, Your Honors.
Ms. Powell?
Comments about Beam. Again, Beam is completely in line with every North Carolina Supreme Court case that says for decades, when attempted conduct is in the statutory definition of an offense, that is the legislature's intent to make an embedded inchoate attempt statute, and that's exactly what Beam is doing. And I showed a number of other cases in other contexts where they say take or attempted to take, etc. The fact that 9098 has never been used to charge an attempted deliver offense means that Groves just simply is irrelevant. They are not used. The actual language of the statute itself, 9098, says, except as otherwise provided in this article, this applies. And the cases have said that kind of language is meaning when there's attempted conduct that is expressly provided for, that's when it applies. And so
how do you account for the language in 21 U.S.C. Section 846 that seems similar, any offense defined in the subchapter?
the language may be similar, but the way every state has interpreted similar language can be wildly divergent. As we discussed, some jurisdictions do exactly this as the government's position, while others that we noted read the attempted conduct as an embedded statute, inchoate statute, and treat it that way. They apply the elements of their inchoate offense, whether it's overt act or substantial step. So there is a divergence here, and North Carolina is not the same, despite the same language in how they treat this kind of statute. State v. Moore has said unequivocally that it doesn't matter what you prove. You can prove sale, you can prove delivery, you can prove either or both, and thus the bill of information, regardless of what the G says on his automated entered judgment for the sale delivery, the bill of information the government actually introduced late in this case, the offense conduct is sale or delivery, and thus, regardless of whether they call it Class G or not, his offense was for the broader sale or delivery under United States v. Van and other cases. So it would not render any language superfluous because the entire North Carolina criminal structure treats in any case, whether it's attempted safe cracking, larceny, delivery, when there's attempted language in this definition of the statute, that's an embedded inchoate offense. And finally, I wanted, in the time remaining, to try to emphasize the difference between a felon and a crime punishable for more than 1 year. They are not the same thing, and so it would be as if I said what the government, what the state, the judge, excuse me,
Ms.
said.
Powell, you can argue that, but you know, when the federal statute defines what a felony is, and that applies to 922G.
No,
it
that does not.
apply.
No, I disagree respectfully. Jerome v. United States, Burgess v. United States discussed at length why it used to be called any felony. That was changed because of the vagaries and disproportionateness of that understanding of that word. Even in the 40s, with Jerome v. United States and Burgess v. United States, that word felony was recognized to be squishy and open to the vagaries of different states. And so they used a technical term, crime punishable, etc. If I had said, you must not eat lamb, beef, or venison, in other words, any meat, I have modified what I just said with what followed, as is all those cases that I showed. And that is what the district court did. The 922 does not use felony as it's defined in federal law expressly, and the reason is from those early amendments to remove it because of the variances of state law. And that is my time, but I thank you very much.
Thank you, Ms. Powell. I want to, you're court appointed,
Yes.
and I want to recognize that service. It's very, very important to make our system work, and we very much appreciate it.
Good morning, Your Honor. May it please the court. David Leitz for the appellants. With me today is my co-counsel, Carl Solomon. The order of the district court here must be reversed and the judgment vacated. Summary judgment was granted because the named plaintiff appellants could not show proof that they were actually viewed through the window from the coach's office into the student locker rooms. The district court held that proof of actual viewing of the named plaintiffs was required in order to establish the tort of intrusion into private affairs under South Carolina law, and that without proof of actual viewing, plaintiffs and appellants could not demonstrate that they had suffered any injury. However, South Carolina law does not require proof of actual viewing, just as it's not required in a score of other states that have decided to follow the restatement second of torts.
So this is a little bit, you know, I know your camera cases and stuff like this. The allegation here is that Mr. Schofield was in that room taking pictures.
Yes, sir.
And if we have absolutely zero proof that he was in the room taking pictures at the time that the plaintiffs were in the locker room, they have his pictures. Nobody's purporting to say that they're shown on the pictures. The girls, the women, young ladies testified they never saw him in that room. They saw a coach in their room, one of them said. Another one, they saw a coach outside. Another one said they met a coach in that room. No one ever saw Schofield in that room. It comes down to the basic question of whether there was any invasion of privacy with respect to them. And the difficult question in my judgment in this case is whether this is a 12b6 issue that it just failed to demonstrate the element of injury of any kind. I mean, not even injury, of conduct. They're told years later that he was taking pictures and they were embarrassed by that. But there's nothing to suggest that he took a picture of them or was even in the room when they were there. They said they could see the coach in the room, but they never saw Schofield in the room. So the court dismissed it on standing, and I think if it's a standing issue, I think your point's pretty well taken that it's got to be without prejudice because you'd be just in the wrong forum.
I think that's absolutely right, Your Honor, and that if the court did rule on standing, it's clear from what the nature
Was the motion for summary judgment, did it include also a failure to state a claim?
It did not, Your Honor. I mean, it was styled as a summary judgment motion, but the entirety of the motion is one or two sentences, and it basically just says, because the plaintiffs have suffered no injury, that in fact, they have no standing, and the court found that as part of the class certification analysis, and that under TransUnion, which is clearly a standing case, therefore, their claims should be dismissed. That's a 12b1 dismissal, and under 1447C, the court has...
Your argument would be that if we were to uphold the court, we would have to do it without prejudice and then send it back to the state court. Is that your...
That's correct, Your Honor. So that's argument number two.
Yeah.
But argument number one, I want to address what the court was just saying about Mr. Schofield and the actual viewing. So first of all, it is not merely the
Well,
allegation.
isn't there a threshold question, though? It seems like all your claims revolve around whether or not this actual viewing is a required element, and what are the elements of this crime of intrusion into private affairs. And one way to look at it is that the intrusion is itself a separate element, and it's a condition precedent to whatever else may follow. And the South Carolina cases seem to be somewhat contradictory there. A lot of the language relies on cases where there's no doubt there was an intrusion. And I'm not aware of a particular South Carolina case that specifically says an intrusion is not required before you go on to the remaining elements of the tort.
Well, Judge Agee, the O'Shea case is actually probably the most on-point case on that particular point. And it's not that an intrusion isn't required, it's how you define what an intrusion is.
Well, doesn't that get you to the threshold question of is actual viewing a requirement of intrusion?
Yes, Your Honor. And in O'Shea, we see that it isn't, because the South Carolina Supreme Court really just bypassed that whole question about whether or not actual viewing or acquisition of data was required.
Yeah, but it didn't really deal with the issue of whether or not there was a predicate intrusion, if I'm remembering that case.
Well, in O'Shea, Your Honor, there was no
Correctly.
question that the neighbors could see into their neighboring,
Yeah, but that begs
folks'
the
house.
question, was there an actual viewing or was there not an actual viewing? So I don't think that case, at least to me, doesn't really answer that question, which is why the query comes to me whether or not this is something we ought to let the South Carolina Supreme Court say, is what exactly are the elements of this tort, and whether or not you're right, actual viewing's not required, or whether it goes the other way.
Absolutely, Your Honor, and that's actually something that we moved for at the district court level. We asked for certification of
Yeah,
this
but let me
question.
go back to my question, though. I think that's an interesting question if you get that far. But in this case, there was no intrusion. There was nothing. He wasn't even there. They can't establish any type of element of that tort, not even the number one element. This is an invasion of privacy. It's one of the three subcategories of invasion of privacy. And Schofield is alleged to have invaded their privacy. But they have no ability, and they were deposed on this, and I read their depositions entirely, all of them, and they don't testify that he was even in the school at the time, much less in that room. And so my question is, if they can't establish they were hurt by a tort, that's standing. If they can't establish the element, it's 12b-6. It's that old steel company problem, what we have to address first. And the district court said there's just no injury. Nothing happened. I mean, why are we worrying about an intrusion when you haven't even alleged an intrusion, demonstrated an intrusion on the summary judgment?
Well, Judge Niemeyer, I credit your reading of the depositions and your recitation of the facts of the case, and certainly there's no quibble with what you're saying about Schofield, but where you're taking a wrong turn is that it's not merely the allegation that Schofield is the one who is committing the intrusion. It is generations of employees of Bishop Inglis
You have to start with the plaintiff, representative plaintiffs. You have nothing except their claims. Representative claims of the other people who were exposed, that's been handled. They know the pictures, they know what's on them. My point is the plaintiffs that are in this case testified, and they were unable to testify that there was a tort committed against them. There was no suggestion that, and the tort is Schofield's taking pictures, videos or pictures, whatever, both. And there's no claim that he was there, that he took any pictures of them, that they saw him. You have no ability to say that these particular plaintiffs were, a tort was committed, they were injured in any way. Schofield clearly had committed wrongs against somebody. And those pictures are, as you know, they're locked up and so forth. But I'm getting to the point, we're parsing a tort when there was no tort in the first place.
Again, Your Honor, the tort isn't limited to Schofield's.
Who else?
You have to have proffered evidence at summary judgment to show you've got some plaintiff out there who was seen by somebody and you have to identify them. So did you proffer that evidence?
The evidence, yes, Your Honor, is proffered in that there's testimony from the principal of the high school that students were viewed through the windows. So the intrusion isn't just limited.
So you have somebody 10 years ago that's viewed through the windows. You have 3 current students who were never viewed. He was never in that room, never took pictures of them. And they have standing to sue for the injuries caused to those other students?
Yes, Your Honor, because it's generations of students who are being viewed by a whole
There's
panoply.
not any typicality, a commonality of any kind. These students were not hurt. These 3 students were not viewed. They were not photographed. He didn't even see them. They didn't see him. And you're saying they can represent other students who had torts committed against them?
Yes, Your Honor. So for 20 years, the testimony of the principal of this high school is that the window was in place from the coach's office into the locker rooms, and that personnel viewed the students repeatedly generations of students over this 20-year time horizon through that window. So there is testimony in the record that basically says
Sure.
that
So
all of
He
the,
went to jail, didn't he?
but Your Honor,
And we know exactly what he took. We have his pictures, we have the cameras, we have the videos.
that's correct, Your Honor.
So, I mean, you're just, it's sort of like, you're saying that the 3 students who were not injured can sue for, sort of like there's a systemic injury?
It's an injury to approximately 7,500 students over a 20-year time horizon who had
I'm talking about the 3 students. How many we have as representative plaintiffs?
Yes,
3?
3.
Okay. Were they injured?
Yes, Your Honor, they were
How?
injured. There's testimony from the principal of the high school that school personnel viewed them through that window. And
You,
so,
those 3 plaintiffs.
well, 2 of the 3, Your Honor. One is a parent plaintiff.
Yeah, one's a parent. That isn't what the testimony was. I read the testimony. And they saw 2 coaches in there from time to time, and one of them went in the coach's room and talked to the coach in that room. Those are the only people, and one saw him in the hallway, but never Schofield. And the illegal conduct here was the photographing. Well, okay, I understand what you're saying. I just have,
I'm saying that you shouldn't focus on Schofield
I would
relative to the name.
focus on the 3 plaintiffs. That's what we
Right.
have to focus on.
Right, but we're not making an allegation that Schofield saw these plaintiffs. We're making an allegation that there's an admission by the principal of the high school that other personnel saw these plaintiffs. And that's what is sort of the common.
These 3
conduct.
plaintiffs?
The 2 of the 3 that are students, that students were seen through the window, and it's
But
also.
they didn't identify these 2.
Right, but this also gets back to the primary question.
I mean,
Is
we're
it-
just sort of guessing, you know, it's sort of like, I'm a student at the school, a lot of students were hurt, and therefore I was hurt. That isn't what the tort system is. The tort system is you come in and an individual said, I was harmed by improper conduct.
That's right.
And these 3 people cannot say that, and have not said it. As a matter of fact, they said the reason they were bringing the lawsuit is to support their classmates. I mean, they were very honest and candid. It was sort of beautiful. They were stepping forward and saying, we'll participate. They were asked to participate. They didn't ask themselves. They were asked to participate, and then they said they agreed so they could help their classmates. That was what they testified to.
Yes, Your Honor. Again, this goes back to what is an intrusion under South Carolina law. And
There's no intrusion on them. You haven't alleged it.
we have alleged it, Your Honor, because it's the fact that they could be seen through the window. It's whether or not we need to actually provide evidence of actual viewing or acquisition of data under the intrusion tort. And if South Carolina is in accord with Section 652B of the Second Restatement of Torts, which is what we argue in our briefs,
I think it's
then-
all academic. I mean, it's academic. We're starting to something, we're talking about whether you were in the automobile accident.
No, Your Honor, if we go to the O'Shea case, again, the South Carolina Supreme Court acknowledged that the neighbors could be seen. They only found that it's just not outrageous enough to be seeing your neighbors through the window, because in modern society, that's kind of a fact of life, that we all live close together and that you can see through. But the South Carolina Supreme Court didn't have any problem whatsoever finding that there was an intrusion because of the ability that they could see, that they could peer into their neighbor's living room. So that claim failed for a reason that didn't have anything to do with whether or not an intrusion under South Carolina law requires actual viewing.
I think you're right to the extent that other states some states have been very clear, right, that potential for viewing can be an intrusion if it's out, and maybe it goes to outrageousness, but it has to be outrageous enough, right? That the
Correct.
fact that you could have been viewed can be an injury in some circumstances. My question is just, South Carolina law doesn't seem clear really to me one way or the other on it. O'Shea skips over that question, and it seems like a number of states have taken that. That's a very defensible position, that potential for viewing can be enough for the tort. But it's not clear to me that South Carolina has said that.
Yes, Judge Rushing, and that's sort of our point, and it was our point when we asked for certification of the question, that Snakenberg did seem to muddy the waters under South Carolina law. up to that point, it seemed like South Carolina law, I see my time is up. May I finish my thought? That South Carolina law was going down the path of all the other states that had adopted the restatement more formally, and that it was in complete accord, sort of adopting this complex of subtorts under the invasion of privacy tort. And there's nothing to suggest that South Carolina wouldn't sort of interpret that intrusion upon seclusion or intrusion into private affairs tort differently than the restatement states that have said it more firmly. So, you know, Snakenberg kind of muddies the waters, but not really, because it has this sort of catch-all phrase at the end, and then you also have the fact that Snakenberg says it's a fact question. So, you know, I think at worst, this gets certified to the South Carolina Supreme Court to sort out the muddiness, but we think it's actually clear that South Carolina's like the restatement states.
All right, thank you.
Thank you, Your Honor.
All right, Mr. Dukes.
May it please the court. I'm Richard Dukes. I represent the Catholic Diocese of Charleston, which encompasses the entire state of South Carolina. The now retired Bishop Robert Guglielmone and the operation and ministry of the diocese, Bishop England High School.
It sounds like the threshold question is, can we reach the issue of standing without first determining whether or not there's an intrusion?
Well, Your Honor, this court has already interpreted the tort of intrusion upon private affairs under South Carolina law in John Doe 2 versus Associated Press, and the citation is 331 F. 3rd 417.
Is that in your brief?
It is not, Your Honor. In that case, it was a...
Hey, tell us what that is again.
Yes, sir. John Doe 2 versus Associated Press, 331 F. 3rd 417. In that case, the panel of this court said, to be liable for wrongful intrusion into private affairs, a defendant must have engaged in conduct that resembles watching, spying, prying, besetting, or overhearing. In that case, it was a victim of childhood sexual abuse who had testified in court at the sentencing hearing of his abuser. There was a reporter in the gallery.
Did you file a 28J letter to alert opposing counsel to that case?
I did not, Your Honor. As it's a published opinion, he didn't mention the case in his briefing either. However, I will also point out, and I can file a 28J or supplemental briefing on Doe 2, and the most recent case from the South Carolina...
Go back and tell us why you think this John Doe 2 case resolves this issue.
Because this court found that under Snakenberg, the defendant has to have actively engaged in watching the plaintiff, watching or spying. And the term this court used in Doe 2 was the reporter did not illicitly obtain information regarding the plaintiff. And I think that is on all fours with this case. In our case, there's no evidence that any defendant illicitly obtained information about these plaintiffs. And I think that ends the question for whether there's an intrusion. And remember, in O'Shea, the Supreme Court didn't discuss.
So is that because in Doe 2 they were testifying in public in a courtroom in the court?
That's
And
correct,
we said
Your
that's
Honor.
not an intrusion into privacy, you're in public.
But
How is that like a locker room?
the locker rooms, as Justice Scalia noted in Veronia School District 47J, high school locker rooms are not known for their privacy. And he also said that high school sports are not for the bashful.
So this is a totally different argument than you've been making thus far in this case, right? Instead of saying they weren't viewed, you're saying, well, they were viewed, but everybody knew they were going to be seen naked in the locker room by the coaches.
No, Your Honor, I'm arguing that they were not viewed, that viewing is required, and they were not viewed.
And that quote from Doe 2, that's Snakenberg, right? We're
Yes, Your
using
Honor.
the Snakenberg language, may consist of watching, prying, spying, besetting,
And-
overhearing, or other similar conduct.
And cited directly to Snakenberg. Yes,
Right,
Your
we're
Honor.
not deciding anything new, we're just citing Snakenberg for what it says.
That's right. That's right.
So we didn't decide anything above and beyond what we already have from South Carolina law.
No, Your Honor.
Thanks.
So, well, your opposing counsel, though, as I understand his argument, says that the principal of the school admitted that one or two of these named plaintiffs was viewed. Is that accurate?
No, Your Honor, it's not. The principal was asked in a question to which we objected. I feel certain because of the way the questioning went. But he said, when you agreed that the students were monitored while they were in the locker room, the principal went on to say that in his experience, the mini blinds that covered the window were never opened. He never saw them opened. Nobody ever reported to him that they had been opened. These students said that they never saw the blinds opened, or a teacher or staff member or coach looking into the locker room. So they are mischaracterizing the totality of the principal and associate principal's testimony, which said that coaches were in the offices. Yes, they were charged with monitoring the conduct of students to hopefully, if a fight broke out or hazing was occurring, they could go in there. The windows were placed in there and designed by professional architects within the standard of care at the time the school was built in order to, as a safety mechanism. And as near as we can determine, there are no reports of misconduct in the locker rooms over the years, but who knows whether the presence of windows and teenagers knowing that an adult is on the other side prevented hazing or fighting or other misconduct in the locker room. We just can't know.
So is it your view of the record that there's no evidence that the three named plaintiffs were actually viewed?
Not a shred of evidence, no, sir. And as Judge Niemeyer pointed out, this complaint, well, in answer to what Judge Niemeyer was asking, this complaint was 28 pages long, I think contained more than 100 separate paragraphs. The defendants did not know who the actual plaintiffs were for months after we had answered the complaint. They would only reveal the identities of the students to us after Judge Gergel entered a consent order of protection. So when we answered the complaint, we couldn't know whether it was one of the students that we knew had been viewed or not. Because the district court considered matters outside of the pleadings, even when it goes to standing, it goes under Rule 56 and not under Rule 12b-1. And that's exactly what happened. As Judge
Well, you can do both. I mean, you can decide 12B, you can decide subject matter jurisdiction on a summary judgment, or you can decide failure to state a claim on summary judgment.
And that's
Or you can do it under 12B1 or 12B6. It doesn't matter.
And we moved forward under Rule
But
56.
the court granted standing under, during the summary judgment.
Well, the court found that these plaintiffs had suffered no just legally cognizable injury, and therefore they lacked standing. But standing can be raised at any time by the defendant, and as Judge Childs...
But wouldn't it have to be without prejudice?
No, Your Honor, because...
I've never seen, I mean, basically standing is whether well, maybe not in terms of standing, because standing goes to the...
whether there was a legally cognizable injury.
Cognizable injury.
In fact. And after discovery, the district court had sufficient information outside of the pleadings to determine as a matter of law that they had not stated a claim for which relief could be granted. So our position is that the district court followed the proper procedure in dismissing the plaintiff's individual claims on Rule 56 grounds. I'm happy to turn to matters of class certification, if Your Honor would.
Well, we have to, the class issue only survives. The only thing that is really before us is the 12, if the court was wrong in throwing it out under standing, then it seems to me you could raise a class issue, but the question is, the plaintiffs themselves have to have standing
And
to represent a class, and each member of the class has to have standing.
that's correct, Your Honor. And in this case, through discovery, we determined that the plaintiffs, the two students and the parent plaintiff, had no legally cognizable injury. They could not meet the elements of the claims they had asserted, and therefore summary judgment was appropriate. We relied on the district court's determination on class certification, in which he found they were inadequate plaintiffs because they had no legally cognizable injury. And on that basis, we moved for summary judgment, and the trial court granted that motion. And because he had considered matters outside of the complaint, Rule 56 was the proper procedural vehicle. As Judge Childs noted in Ray Blackbaud, the case cited by my colleague.
Well, that's not an issue.
So it was at summary judgment that the standing determination was made?
Judge Gergel made a determination at class certification that these plaintiffs could not establish that they had been injured, that they had not suffered any injury in fact. Based on that previous determination, he again found that they had suffered no injury and therefore they lacked standing on summary judgment.
So to summarize, he found that they lacked standing, so there's no jurisdiction, and then he granted summary judgment.
I disagree that there's no jurisdiction, Your Honor, because the defendants invoked the original jurisdiction of the court under the Class Action Fairness Act. We removed the case based on CAFA because this class action qualified on what Congress gave the federal courts original jurisdiction over. Class action has to be worth more than $5 million. You have to have more than, I think
It's a diversity jurisdiction. CAFA is a diversity between one member of the class and the plaintiff. And it's under 1332, it's D, right?
Yes, Your Honor.
Okay, and that's what it is. And
So you think Article 3 standing is not a jurisdictional question?
Not when Congress has granted original jurisdiction to the federal courts for a particular action. Our position is that when you remove an action under CAFA, essentially the courthouse door closes behind you and the district court can make findings on the merits, irrespective of where the class action goes.
So there's no case or controversy, but as long as it's under CAFA, you can decide the merits.
That's our position, Your Honor, yes.
And you think whether they satisfied an element of the tort goes to whether they have standing?
It goes to whether they have suffered a cognizable injury. And whether you call that standing or call that failure, an absolute failure of proof of the essential elements of your cause of action.
That's what the district court did here first,
Yes, Your Honor.
at least chronologically.
He denied class certification, found that the plaintiffs had not suffered a legally cognizable injury, and therefore they were inadequate representatives of the class. We followed up with a summary judgment motion based on that ruling in order to dismiss the case
So
on
then
summary
he
judgment.
finds they don't have standing, which means there's no subject matter jurisdiction. And we have this language in the removal statute that says if the district court determines that, then the case shall be remanded.
I think that procedure would defeat Congress's intent in passing CAFA in order to allow defendants to get in the courthouse door on a mass action or a large-scale class action. I think
this is a little dicey because the basis for federal jurisdiction under CAFA is diversity. And the basis for remand is if there is a lack of diversity. And the question is, when you remove it under CAFA, the court clearly has the power now to address the case it finds there's no standing. That is also subject matter jurisdiction. And standing in this case blurs also with an element of a tort, because every tort requires injury. And when there's no injury, you dismiss the tort or you can find no standing. And so the question in this case is, the court now finds that it doesn't have jurisdiction and it dismisses the case. So the question is, when it dismisses it for standing, does it have to remand it under the CAFA statute?
Well, the CAFA statute would require remand under certain circumstances for lack of diversity or
Right,
lack of
right,
sufficient diversity.
right.
There's never a motion to remand in this case. So the defendant satisfied their burden under CAFA to show minimal diversity. The court then has the power to hear the case. The lack of standing is a merits issue that the court can determine after the case has been remanded. And I think it would be improper to remand the case under 12b1 or the removal statute, because the diversity still exists, the minimal diversity that gave rise to CAFA jurisdiction still exists.
Well, if we assume, just for purposes of argument, the South Carolina Supreme Court determined that the threshold element of this tort, intrusion, did not require actual viewing, and that's established South Carolina law, how does that affect the standing determination in this case? How would that affect it?
It would confirm that these plaintiffs had not sustained any legally cognizable injury, in fact.
That if they're not required to be actually viewed, that the potential for viewing was sufficient. You still say that would defeat their claim?
Well, then, if potential viewing were required, that would be entirely speculative and would.
Well, that's the, seems like the question we deal with. If that, you've got this circle of which of these is going to come first, and if we just assume the South Carolina law said, contrary to what the district court found, that you don't have to have actual viewing, the potential viewing is sufficient, then it seems like to me that changes the calculus that the district court used for the standing determination.
It might change the calculus on the standing question, but under Rycroft and O'Shea, the plaintiffs also had the burden of showing, well, under Snakenberg, they would have to show that the intrusion was unreasonable and substantial. There's no evidence to support that.
Right, but the district court never got to that.
That's right. That's right. And then they would, under Rycroft and O'Shea, they would have to go a step further and show that it was the intrusion was blatant and shocking, and that they had suffered serious mental and physical injury or physical injury and substantial embarrassment. And there's no evidence to support that either. And as the Supreme Court did in O'Shea, I think it's entirely appropriate, given the evidence in the record, including the testimony of the architect, the opinions of the architect expert and the school administration expert, Mr. Runyon and Mr. Glick, that this court could determine that it, just as they did in O'Shea, that the existence of a high school locker room with a window from a coach's office is not blatant and shocking, and therefore they lose.
But just to make sure I understand, none of that was decided by the district court. The district court based it on an understanding of South Carolina law that actual viewing is required.
That's correct, Your Honor.
Had not been shown by the evidence here.
That's correct.
I thought it said no injury.
He did say no legally cognizable injury.
Well, that's a viewing may or may not be necessary. Let's assume it's not necessary as the argument. You still don't have an injury.
I agree.
Because their testimony was pretty clear.
That's right, Your Honor. They were very clear that they had never seen anybody watching them.
And they didn't claim any injury. They claimed embarrassment for their classmates.
That's right. That's exactly right, and that's what the record reflects.
So you think the district court conclusion that there's no injury would have to be the same, even if potential for viewing qualified as an injury under South Carolina law?
I think you're right, Your Honor, that's what this record reflects, is that these plaintiffs could not identify any injury that they sustained.
Why? If potential for viewing is enough, they can't show an injury because, why?
Because they weren't embarrassed.
It's not, yeah, not blatant,
They didn't
not
suffer
embarrassing.
serious mental or
Okay,
physical injury.
Gotcha. Moving on to the elements beyond that the district court didn't address here.
That's right.
I see your point. Yeah.
Yes. I see my time's about up. If there are any other questions, I'm happy to address them.
Thank you, Mr. Dukes. Mr.
Thank you very
Leeds?
much.
Thank you, Judge Niemeyer. I just want to first say, we didn't cite John Doe 2 because Judge Rushing has it exactly right. It didn't advance the law at all. It merely restated Snakenberg, and it's just not going to answer the question here about whether or not South Carolina law requires actual viewing or doesn't require actual viewing. So there really was no point to citing that. It's not in the chain of authority that advances the law.
So if we assume that South Carolina law does not require actual viewing, just assume there was a decision that said that, tell us precisely why your complaint as pled and what you've proffered satisfies the requirements of an injury if that's the definition of the element intrusion in the tort.
Yes, Your Honor. It would satisfy it because there's testimony in the record at Joint Appendix 123 that the students were viewed, testimony from both Principal Finneran and from Ms. Eslage that's quoted that says, nobody's ever denied the fact that they were monitoring the children and looking at the children. They deny that it's an actionable cause of action. Answer, yes. Is that correct? Yes. They are being monitored in the locker room in various states of dress and undress. That's a fact, correct. That's not an allegation, correct? Answer, yes. So there's evidence in the record here, Your Honor, of that generations of students were viewed and
Well,
could
how
be
about
viewed.
these three named plaintiffs? What's the evidence that there was the potential for viewing them other than the fact the window was there?
Again, that it's a combination of the circumstantial evidence, and Mr. Schofield's action actually sort of proves the point that students were being viewed in there. It's not that he viewed them, but it definitely demonstrates that people were looking, they were seeing
Do you have
students.
any evidence that particularizes the students to these three plaintiffs?
It is just the generalized.
No, I'm not asking about these three plaintiffs. Is there anything in the record? I couldn't find anything.
There's nothing in the record that shows that basically these two students out of the three plaintiffs were.
Well, it's a student of the parent too.
Correct, Your Honor. But that they were actually viewed. But this, again, it goes to the point. Like, if you have a spy camera there, that's just like.
That's totally different.
Well, let's assume that the window is like a spy camera, and the spy camera is just sort of a constant live feed, and it doesn't sort of record the images. Does that negate the fact that the students were being viewed? It does not. They're definitely being viewed. The mechanism is there to view them. They could be viewed through this mechanism. And the same thing is true here, a 4x4 window going from the coach's office into the locker rooms. I think my learned brethren is trying to rewrite TransUnion on the remand issue. He was the master of his summary judgment motion and decided to cast it as a standing issue alone. And if there's no Article 3 standing, this case gets remanded.
Well, you know, I agreed with you originally on my questioning of you, but there's a couple of twists on that make it a complex issue. The twist is, number one, the federal power to decide this case, and the Supreme Court has pointed to this many times. As a matter of fact, I was reversed by the Supreme Court on this very issue. There was a 1332 jurisdiction, and then I looked at the Communications Act, which said there was no jurisdiction for certain things, more particularized, and the Supreme Court said, no, you look at 1332, it's a jurisdiction of the case. It's an AT&T case. This removal is a diversity removal. That's the power given to the courts. It's a constitutional power, The courts have the right to decide it. Now the question is, the court has it before it, and it sees a lack of standing. Now, standing goes a little beyond just the forum to decide it in. Standing goes to the particular persons, whether they can assert the suit, and whether the court therefore has jurisdiction. So when you say that the person does not have standing, then with respect to that person, it's got to be with prejudice. In other words, it's not the wrong forum, that the federal court versus the state court, as I had talked to you originally, because the federal court and the state court is delineated by diversity, and diversity still was proper at this point in time. The delineation in this case was very close to the 12b-6. It's an element of a tort to have injury. It's also a necessity for standing to have cognizable injury. And when you decide that there's no cognizable injury, you're probably deciding both of them simultaneously. You're deciding we have no subject matter jurisdiction over these plaintiffs' claims. The other claims, it doesn't control, but these plaintiffs' claims, it also says that they didn't have a tort because there's no injury. And I don't know where the cases actually decide that. I know you can start with Steel Company case, and it addresses that. Justice Scalia talked about it at some length there, but it's not a slam dunk as what you're saying. So I agree with you originally.
Well, Judge Niemeyer, you and I have actually chatted about CAFA before. I was counsel on Home Depot versus Jackson, so we've been down this road before. And I think that...
I wish I remembered.
Well, Your Honor, I remember, and it was a pleasure. But I would like to say that basically the defendant was the master of what they wanted to bring up to the district court here. And if they had wanted to go down the road of bringing up sort of the lack of injury in the context of a merits determination and an actual...
Well, they did. The cognizable injury relates to two. And if the court says the plaintiffs in this case have no cognizable injury, but they don't have standing.
Again, Your Honor, that only was found in the context of the class certification.
No, it was found in the summary judgment, too.
Well, no.
He relied on it, incorporated it.
But it's not a merits determination in the class certification ruling.
No, but it was in the summary judgment ruling.
No, Your Honor, he didn't reiterate the presentation of evidence and say that under these undisputed facts and under these affidavits and these declarations that basically the plaintiffs can't show injury. There was no factual presentation.
Well, you're suggesting now that his order isn't sufficiently supported, but he clearly understood the case. He had all the details of the case, and he granted summary judgment, which is a concept of saying the case ends.
No, Your Honor, the district court judge made a denial of class certification, which is not a merits ruling at all. It would be a different inquiry entirely that would be required to be supported by facts and evidence, a factual showing that under the facts, after we've sort of developed the record, that there isn't any injury in fact. There's nothing that prevented defendant appellee from making that motion here, but they didn't do that. All they did was come before the district court and say, there's no injury and no standing under TransUnion. And that is basically what gets you to remand automatically.
Did you oppose the, I can't remember the record, did you oppose the motion for summary judgment?
Yes, Your Honor, we did.
And what did you say in your opposition?
We said that, if this is basically just a challenge to standing and that it goes back, I'm sorry?
Yeah, I'm interested. Did you agree that there was no cognizable injury, or did you object to that?
We did, Your Honor.
And what did you say?
We said that there was a cognizable injury and that the district court was wrong in finding that there wasn't one. We submitted 9 exhibits in connection with our opposition to the summary judgment motion.
So the court considered all that, right?
No, Your Honor. The court was confronted with basically a bare bones 1 or 2 sentence motion that basically just said no injury, therefore plaintiffs lose under TransUnion. And our sort of response to that doesn't make their case for summary judgment. I think my time is up. Long up.
Okay.
Thank you, Your Honor. We ask
much.
that the court reverse and remand.
We'll come down and agree counsel and proceed to the last case. Atkins versus CSX Transportation, and I guess Mr. Dingwall's first up.
Thank you, Your Honor. Good morning. I guess we're still morning. And may it please the court, I'm Jeff Dingwall on behalf of the appellants, and I'll be sharing time with my co-counsel here, Greg Paul. I'm going to be addressing the procedural issues, and then Mr. Paul will address the substantive legal issues, including the FMLA interference and the honest belief issues. The district court here, in just 2 short pages of analysis, granted summary judgment against more than 50 plaintiffs, including the appellants here, and in doing so, made clear credibility determinations in favor of the defendants as the moving party, weighed evidence against the plaintiffs as the non-moving party, and resolved all inferences against the plaintiffs as to their evidence. And this really comes into focus when you consider the 2 proffered reasons that CSX and the defendants gave for firing the plaintiffs in this case. Number 1 is they claim that the plaintiffs were engaged in a conspiracy to defraud the company and numerous benefits providers. Now, the district court held that Dr. Helligman believed the plaintiffs were engaged in fraudulent acts, and the district court used that as a basis to state that the defendants had asserted a legitimate non-discriminatory reason for the terminations. But the district court ignored the fact that Dr. Helligman testified in depositions that he had no such evidence, that in fact it was pure speculation, that's a quote, that he felt the plaintiffs were engaged in a, quote, unconscious effort. And Dr. Helligman testified that he took no issue whatsoever with the documents that were submitted on behalf of the plaintiffs by the chiropractors. Specifically, he said he took no issue with the diagnoses that were on the forms or the treatment that was prescribed. He simply had no such evidence whatsoever that there was.
He looked at the circumstances and said these circumstances smell. You have 50 people giving the same type of claim, going to the same chiropractor, getting the same report, getting the same 8 weeks off or whatever it is, and all coming up to potential furlough of some of them. And he concluded that this didn't smell right, that the injuries were of different magnitude, that they were more particularized. And I must say, if you presented the facts, the similarities to some jury, they would say it smells too. And I think they acted on that. That's what they were acting on. And your questions to the company representative was basically, sure, it's speculation. All circumstantial evidence speculates to some extent. It fills gaps. But there was real evidence there that supported what the, or tended to support what the company concluded, which was that this was a program to extend benefits or to get benefits without justification for them. Now, it's not 100% sure, whatever, but that's the way they acted. And I think to parse the testimony and say he said it's speculation and this, sure, it is speculation. When you don't know something, it's got to be speculation, but it's reasoned speculation based on the other facts that you do know. And so I think, to be fair, that you have to recognize the indicators that make this case look strange.
Sure. And I don't think anyone here would ever suggest that a company couldn't look into something like this or even shouldn't look into something like this. Part of the issue here is that the company swept everybody out with the same
Well, the
group.
50 people they were all fit that pattern. I mean, the gross aspects of the pattern, and I didn't give you all the details, but it even goes to the same language and goes to the same two healthcare providers and timing and everything else. It's hands down, 16 on a given day or something. You know, it's the similarities are striking. But anyway, I just wanted, you were sort of tending to suggest that the company was acting baseless by saying they were relying on speculation in this stuff. And I think the record's pretty strong that they were acting in response to something serious.
They were certainly reacting to something, and Dr. Heligman's testimony has been pretty clear that he thought there was a pattern, and that's what he acted on. But when you really get into the facts, and you look at what they actually accused these individuals of, when they accused them of it, and then the actual evidence that they had to back that up, it's a very different story. And in fact,
when you say what he acted on, what's in front of us is the termination and the FMLA decisions, right? And none of those actions weren't taken by the doctor, right? The doctor presented testimony to a labor relations team who made a recommendation to a gentleman who then made this decision, right? So the decision, the action in front of us is not the doctor's decision to investigate. It's the multi-step process required by the CBA, I believe, to make this decision, right?
yes, and that's where the ruling by the district court gets a little muddled, because on the one hand, the district court credits Dr. Heligman for his belief that there was this fraudulent activity going on as evidence that this was a legitimate non-discriminatory reason, but on the other hand says that we cannot rely on Dr. Heligman's actions to prove our case of pretext. So, and the district court then goes on to say there was an unnamed decision maker. And
I thought it was named, I thought it was Brian.
He was named in the briefing, but the
Brian
district
Barr.
court did not name him, and also did not make any findings as to what he may or may not have relied upon. So the evidence before the district
Isn't
court.
that your job? If you're supposed to show pretext, you're supposed to show what Mr. Barr relied on that was not the legitimate reason?
Yes, and we did present this to the district court, and I think it's undisputed that Dr. Heligman was the only witness in these disciplinary investigations to present the company's case. There was no other evidence brought in. So the only thing that could have been relied on of the chain is the evidence that Dr. Heligman presented. And even beyond that, if we want to look at this process, this collective bargaining process, as we cited in our briefing, the Fresquez case out of the 10th Circuit, that court looked at it and said, yeah, sure, they have this process that they follow, and they have to follow it, but it's the province of the jury to determine whether that process is weighted in favor of the employer. And that's certainly the case here. Every step of the way in that process is controlled by the employer. In fact, there's obviously no attorneys, there's no discovery, there's no advance notice of the charges. They don't know necessarily what rules are even being brought up to.
But on most of the claims you were talking we're talking about a pretext issue,
Right.
Not on the interference. I know your argument on the honest, that's another issue. But on most of them, we have the McDonnell-Douglas thing, and you're trying to poke at the pretext. And it seems to me that you have to focus on the decision maker and and what he had before him, and not the weakness of the underlying evidence, which maybe did not come to him. He acted on a recommendation and on the data that was presented to him and made this decision. And the question is, was that a pretext for something else, or was it a real response? And I suggest there's a really strong, as a matter of fact, it seems almost conclusive, strong evidence that the only reason he acted because he believed there was not a conspiracy, but a group of people that got together and said, this is what we're going to do to get additional benefits. And they all called in sick and all had the same doctors and all the same days, same amounts and same symptoms. And so the man says, we'll fire him. But that's the reason he did it. He may have been wrong, he may have been right, but the question is, was it pretext? And that's where I think you probably have to direct your attention if they're wrong. And you have to say the reason they gave is not the real reason.
Right. And to the decision maker issue, the problem is we just don't know from the district court's opinion what it.
No, but you know what the record says.
I know what the record says, but we still have to rely on what the judgment was. And the judgment in the four corners made no reference whatsoever to, on the one hand, he credits Dr. Heligman's testimony and does so in favor of the moving party. On the other hand, says we can't rely on that same evidence or his same actions to prove our case of pretext because somebody else made a decision. And it can't cut both ways. And so on the evidence of pretext, we have all this information that we've put forth to the district court, including the fact.
Information that was presented to the decision maker. That's the key.
Correct.
Because the decision maker may not have had all the evidence. The decision maker is making a decision based on what's before him. And in this case, that's what you have to focus on, because the question is whether the decision maker is honest in making the decision or made it for some other reason, or was a cover-up, a pretext for something else.
Correct. And we know, and I think it's undisputed, what was in the record before the decision maker, because the record is cold.
Thank you.
The record is what happened in these investigations, and we know what happened in the investigations. We know what Dr. Heligman said, and then we know what he later said. And his testimony is completely at odds from what he said in these investigations to what he said under oath in the deposition.
All right, I think you have some rebuttal coming. We've let you go here.
Oh, I'm sorry.
Beyond your time. We'll hear from Mr. Paul.
Thank you.
Good morning, and may it please the court. My name is Greg Paul, and I want to thank you for allowing us the opportunity to have this oral argument. I want to start first just on addressing the FMLA interference. Not going to get into the history about the prescriptive and proscriptive, because this court's ruled on that in Sharif versus United Airlines, and particularly at page 203, quote, unlike prescriptive entitlement or interference claims, employer intent here is relevant, referring to that case, which was only a retaliation. So I think we're all clear on that. What gets a little difficult is knowing that an interference claim is a benefit. It's much sort of comparable to an ERISA benefit. It's either approved or denied, and those are really the options. What happened here was not insignificant. As we set forth in the brief in some detail, the FMLA process, which everybody admits the Certificate of Ongoing Illness form is not an FMLA form. That's something that is recognized in the record as notifying the company of possible FMLA. And then what that would have triggered is critical. It would have triggered a medical certification form that the employer or doctor had to complete within a certain period of time. I think it's 16 days. And then the employer looks at that, and it has questions. It can ask them, seek clarification. It can get a second opinion, a third opinion. And so all of that would have showed the company whether this was a legitimate medical absence or not. And that didn't happen. And it didn't happen. There's testimony from Dr. Heligman and the nurse that worked there that boxes were checked on their screen that this should have been FMLA eligible. And that benefit never got processed.
Can I ask you kind of what's the harm question? Looking at the record, it looked like, and I'd like to know if this is right, but looking at the record, it looked like these employees, when they made these claims, and when the company thought something was up, they were all put on leave. And in the district court hearing, the attorneys confirmed that the employees immediately were put off work, and their entitlement to benefits, insurance, et cetera, all continued. And their jobs remained protected until this process played out, and then most of them were terminated, and I think Mr. Stewart was reinstated. But, so I was kind of left wondering, they basically got leave until the process was completed. What's the prejudice?
Well, they got off work, right? I mean, just like anybody could not show up to work when they presented that evidence, but they got a charge letter, right, and had to have a hearing. So much like someone who takes a leave, and actually a lot of the cases that defendant cites are people who were approved for leave, and then they did something kind of weird on leave, right? And whether it's going to the construction house or riding a snowmobile, whatever. But those type of cases, that calls into question like the legitimacy of the leave. But here, what's important is their leave was never protected, which is why they ultimately got fired. Had they been advised of their FMLA rights and responsibilities, submitting those forms would have made it legitimate, would have made their jobs protected for 12 weeks. And so the fact, yeah.
That's all right, but what harm did they actually suffer by by the company not instigating the FMLA warnings process and letting them know that? What was the actual tangible harm to them?
Well, the tangible harm is, not to repeat myself, but all of those medical forms would have substantiated the absences, and the collective bargaining agreement process is not suitable for that. I mean, that's a totally different process. So by nature of having their doctors being able to substantiate or not substantiate the absence, whatever the case may be.
But they could put all that evidence in during the collective bargaining, the pre-approved process, right?
Not the FMLA paperwork, not the FMLA
Their
process.
doctors, I mean, they could have put in evidence from the doctors saying this really was legitimate and all that.
The collective, I mean, I think that's a separate issue. I guess they could have done something, sure, but the FMLA.
So you're saying the prejudice is, if they had gone through the FMLA process, there would have been a different outcome. They wouldn't have been fired.
Well, some may have, I mean, I don't know, but there are two different paths. And what I'm saying is that the FMLA path, this federal law, is totally separate than whatever is required under the CBA. And that would have absolutely, I mean, an employee could have decided not to do it, right? And that's their problem. But by knowing the rights and responsibilities to submit that FMLA paperwork, it would have made crystal clear what their absence was for and whether it was protected or whether it wasn't, right? So that's.
I'm confused by your argument here. I'm still not understanding what the difference is in response to Judge Rushing's question, because there was a hearing process here. And my understanding of the record is that your clients didn't present anything, which it seems like whatever you're saying they could have done by following this other path, I don't understand why they couldn't have done it in this hearing. So I'm having trouble understanding what the deficit is.
Sure, that's a great question. I mean, they're separate paths, but a lot of the individuals, when they got this letter saying you're accused of being in a conspiracy to engage in fraud, had no idea what it meant, right? They knew that it was triggered by the certificate of ongoing illness for sure, but that's all they knew. But by the federal law, FMLA is not overridden by a CBA. It's a separate path, and that path would have clarified their medical conditions, what their treatment was for, and so that's really significant harm. In addition to the fact that most of those
So you're saying under the process that came about in this case, they could not have known any of those things? I mean, they had lawyers, right?
They did not have lawyers. No, they're represented by a union representative talking about a work rule, and their union representatives are often just coworkers. So there's no lawyers. There's no.
What's the sequence on here? The sequence is they took leave pursuant to the doctor's orders, right?
Yes, they submitted the COI form. They faxed it, or someone faxed it, yes.
And they each got 8 weeks leave there, right?
Well, the doctor's form suggested a range of 6 to 8 weeks, but they were charged for submitting that form.
I understand, but the sequence was they took leave. Now, do you argue they should have gotten notice for FMLA?
And Your Honor, it's not just an argument, it's testimony from the FMLA coordinator.
I know, but when?
As soon as that COI form came through the fax to the medical department, that triggered notice. That was notice of the
All right, so let's assume, just for the hypothetical here for a moment, that their claim for leave, medical leave, is fraudulent. And, but they get the benefit of it, they're gonna leave. And now you're saying they should have been spared that conduct because if they had gotten the FMLA notice, they wouldn't have gone through the fraudulent conduct.
Not necessarily. Like you said, there are two separate paths. If somebody submitted an FMLA certification form, and in any case, and an employer thought it was fraudulent, they can question that. There's a procedure under the FMLA to do that, and they can either approve it or they can deny it. And if they deny it, then that's unexcused absences, and they can be charged with that, right? Or if they do something else, they can be charged, but it has to be approved or denied. And that paperwork triggers that process.
It does trigger it, but the process was, the whole thing was triggered by their, let's assume it's totally fraudulent. This is all made-up injuries, and they just went and took leave, got this doctor's business, and you're saying because it's fraudulent, they still should have gotten an FMLA notice after they turned in their fraudulent document?
I mean, under this hypothetical that it was fraudulent.
Yes,
right? Okay,
yes.
sure. I mean, that form would explain.
In other words, they turn in the fraudulent document first, and then the company reacts and gives them a legitimization of that fraudulent.
Absolutely not, Your Honor. What the company is required to do under the FMLA is to give them a blank form that they have, like I said, 15 or 16 days to complete.
Well, I understand, but it
that.
seems to me, it seems to me you're talking about whether they actually have a right, interfered with a right. There's no intent aspect of it under our case law. So the question is whether they interfered with a right. But if it's made up and concocted, there is no right.
Well, it's when I say rights and responsibilities, that's actually, like, there's language in there that tells what the employee has to do and what the employer has to do. So that's more generic language. What's important here is that by getting that FMLA form, right, and it's conditional in any FMLA case, right? I mean, you may be conditionally approved from FMLA, but until that form comes back from the employee and the healthcare provider and is approved by the company, it's not approved. So we're not trying to say, oh, give me the FMLA paperwork and we're free.
Well, my question then gets to the question where Judge Rushing asked you. If their leave was prompted by the fraudulent conduct and they're now on leave, how are they hurt?
Well, because they're not on leave until it's approved, right? And they got charged. So, I mean, it's not just like you give them the paperwork, you're automatically approved.
Well, how much time from they submitted their document for, let's say it's a fraudulent, hypothetical, fraudulent document to get leave, medical leave. The doctor made it all up. In this particular case, how long was it after they submitted the document that they were on leave?
I'm not sure I understand. How long?
Didn't they take leave?
Well, they after they presented the COI form, they did not go to work, and then that was...
They didn't go to work, right?
Right. That's not approved leave, though, Your Honor. I mean...
I know.
Yeah.
They just stayed home from that point on. And the question is, that's all they would have gotten under the FMLA is to stay home.
Well, again, the process is incredibly important here, as I've said, because the medical
Well, it
documentation...
tends to legitimize it, maybe.
It does, and there would be a process for them to challenge it.
But that legitimizes something that was already a scheme or, well...
Under your hypothetical. I mean, right.
Yeah,
At that point, there may have been suspicions, like there could be any suspicions, even on an FMLA form, and that process would clear that out. But the CBA process is not the FMLA process. I know I'm over my time, and I'll maybe address the honest belief.
Okay, thank you. All right, Mr. Schmalzbach.
Good morning, Your Honors, and may it please the Court. This case is, as the Court said, about a purported epidemic of soft tissue injuries, an epidemic that is limited to off-work CSX employees, and an epidemic that appeared immediately after the first furlough announcement was posted in Huntington. The only question that needs to be resolved on this appeal is whether CSX discharged plaintiffs because it believed they had dishonestly participated in that epidemic. And what that suspected dishonesty means is that they sought out 2 whole months of leave, a uniform 2 months of leave, to extend benefits they weren't entitled to. So I'd like to address a few reasons why the district court was right to grant summary judgment. The first is why CSX believed that this was dishonest. Second is why there's no evidence that that belief was pretextual. And third is why the interference claim also should be resolved, and as the court recognized, because there was no prejudice. An absence of paperwork isn't prejudice. It made no difference to them. So starting with why CSX believed that this epidemic was literally unbelievable and showed prejudice. There's 5 particular reasons that this wave of COII forms doesn't pass the smell test. The first is the number. Dr. Heligman called it unprecedented. He had never seen anything like it. Over 60 forms submitted in less than a month and a half from the same 2 doctors. The second reason is the duration. Each of them provided 2 whole months of off work for injuries that, in Dr. Heligman's experience, didn't require anywhere near that long. And the forms included no justifying details that would explain why you need 2 months off for injuries like muscle sprains. Third is that each of these purported injuries occurred off work. Not a single one occurred on the job where they would have been observed by other CSX employees. Fourth is the timing. The announcements of the first furlough was posted on a Friday, and on Monday, we see 16 COIIs smashing the previous record and continuing for the next month and a half. And last, and very significant, is the motive.
So none of the COI forms were submitted before the furlough notice was posted?
There were COII forms for different providers and different plaintiffs, but for the plaintiffs in this case.
The ones in this case.
That's right, Your Honor. And the reason that's important is the motive connected with the furlough. So ordinarily, if an employee is furloughed, those benefits continue for 4 months under the collective bargaining agreement. But the CBA provides a different rule if you are furloughed while you're on medical leave. Then it extends it from 4 months to 2 years, a 6-fold increase in benefits, and a powerful incentive to file these forms, whether they were true or not. So next, I want to address the CBA process, which is a key part of the belief of CSX that this was the product of dishonesty, not the product of an enormous coincidence that all 67 of these forms happened to be filed during this time. So first, the CBA gives all the plaintiffs an opportunity to clear their name. So this is, they are represented not by counsel, but by an aggressive union representative. And I think if Your Honors look at the transcripts of those hearings, you'll see that those union representatives were very active and did a very good job representing their clients. I also need to correct something that my friend on the other side said, which is that the only thing that could have been relied on in those hearings was Dr. Heligman's testimony. It is absolutely incorrect. There was ample opportunity for each of the plaintiffs, each of these employees who were charged, to put in their own evidence, to put in their own medical documentation, to offer witnesses of their own. Another thing I need to correct is that they didn't have advance notice of the charges. They absolutely did. Each of these plaintiffs received a notice of charges so that they were aware what this hearing was going to be about. They were aware they could bring witnesses. They were aware they could bring their own evidence. But it didn't stop there, because even after that investigation hearing, plaintiffs had the opportunity to pursue an appeal to the Public Law Board. And that's important for 2 reasons. One, a majority of the panels on the Public Law Board were comprised of non-CSX personnel. So this isn't a process that's controlled by CSX. And second is that the Public Law Board does actually give substantive review. It's reviewing the decision of the investigation hearing for substantial evidence, which it cites the 1938 Supreme Court case in Con Ed, and it asks, is there sufficient evidence for a reasonable person to draw the conclusion? In this case, the conclusion that plaintiffs had been dishonest. And so what resulted from that in the case of these plaintiffs was a careful assessment of the evidence. You see a great example of this at page 677 of the JA, where the Public Law Board is going through all those same reasons that I just identified and why that shows this was likely the consequence of dishonesty, not of coincidence. And in some cases, the Public Law Board did reinstate some employees who found that they had provided sufficient evidence that their particular COII was the fruit of a legitimate medical need for 2 whole months of leave. So what plaintiffs really want is a rule that employers can't consider the results of public law boards, can't consider the results of the CBA process when deciding whether employees had violated company rules, like the company rule against dishonesty. That can't be right. This is why this process exists. It exists to sort out exactly this sort of factual dispute, and CSX appropriately relied on it here. And for what it's worth, the plaintiffs did concede CSX's belief that this leave was sought for the purpose of extending benefits and not for a legitimate reason at JA 60, paragraph 382 of the complaint, where the plaintiffs themselves alleged that the disciplinary investigation revealed that the defendants believed that more than 60 employees submitted these forms from these two doctors in order to obtain extended benefits. So when you have all that evidence of CSX's belief, and you even have that concession in the complaint, there's an enormous burden for plaintiffs to show that this was pretext. But the court has already identified why plaintiffs don't have that evidence here. The most straightforward reason is that they don't look to the actual decision maker. To look to whether a decision is pretextual, we have to look to the person who made the decision. And here the evidence is undisputed that that person was Brian Barr. You can see the testimony, which is undisputed at JA 2448. And he testified without contradiction that he was the one, he considered the evidence provided at the investigation hearings, and he was the one who ultimately made the decision. And he testified again without contribution. He made the decision to terminate plaintiffs because he thought they had been dishonest. There's no evidence of pretext from anyone else at CSX either. I know plaintiffs want to focus on Dr. Heligman, but he wasn't the decision maker. But even if we consider him, he consistently testified that this spike in forms immediately after the furlough announcement was dishonest, that this was powerful evidence of dishonesty, and that he saw nothing in those investigations hearing where the plaintiffs had the opportunity to clear their names that changed his mind about that. So while he wasn't the decision maker, his explanation is consistent. It doesn't vary. It is always the plaintiff's dishonesty. Now last, I'd like to briefly address the interference claim, and I'd specifically like to address the prejudice problem, because your honors are asking the right question. So what? What is the actual harm to plaintiffs from what they allege are improper processing of FMLA paperwork? So it is their burden to show that there was prejudice, but they have no evidence at all in the record of any prejudice that they suffered. So first, to Judge Rushing's question, you're absolutely correct that the evidence is that they did receive the same pay, the same health and welfare benefits that they would have had they been on technical FMLA leave. So there's no prejudice from what they actually received. Their other argument is that we should have gone through the FMLA process and gotten a second medical opinion. But this court addressed that exact argument in the Rhodes case, which is 257 F. 3rd 373, which was cited in the plaintiff's opening brief. And Rhodes considers this argument that if the company doesn't believe an employee's leave claim, then that employer has to get a second opinion. And this court rejected that argument. It said that section 2613C1, where that second opinion process comes from in the statute, is permissive. It says that an employer may seek out a second opinion. It's an employer's right, not an employer's requirement. But even if there were such a requirement, there's not, but even if there were such a requirement, there's no evidence that it would have made any difference here, because plaintiffs already had that opportunity to show that a second opinion would have bolstered their claim, would have corroborated their 2 months of leave for muscle sprains and similar injuries with legitimate medical need. They had that opportunity, and none of them were able to persuade any of the decision makers along the way that they did have a legitimate medical need for that whole 2 months of leave. So there's no prejudice, and all that the plaintiffs have offered on that point is that they said that that would have given them a chance to show whether the leave was legitimate or not. But that's not the question of prejudice. To show prejudice, they would have to show that, in fact, they would have been entitled to leave. They would have kept their jobs if we had gone through this process, if we had processed the paperwork differently. But it's not enough at this point for an attorney to speculate what would have happened. At summary judgment, the burden was on them to show evidence of prejudice. They have failed to do so. And so for these and the other reasons in our brief, if the court has no questions, we would ask you to affirm.
All right, thank you, Mr. Schwartzman. All right, Mr. Dingwall, I think you're next.
Thank you, Your Honor. I think it's important to remember the posture of this case and how the district court disposed of the case, because all of the findings by the district court in granting summary judgment in favor of the defendants were based on credibility determinations, for example, what Dr. Heligman and what CSX believed, on weighing of the evidence, for example, saying that the district court simply didn't believe our arguments of pretext, and in resolving inferences in favor of the moving party and against us. And that happened throughout the opinion. In fact, it's really the basis, the entire basis for the district court's grant of summary judgment. And that's really the big issue here, is what should have gone to the jury. And certainly there was sufficient evidence of material fact that should have gone to the jury. And that includes the
Well,
CBA.
it seems to me there's really only, setting aside the interference claim, there's really only one question, is whether the decision made by CSX was a pretext. They don't argue about the other criteria. They go right to the pretext issue, and they say there's no evidence to show pretext. And that's an absence of evidence. It's not a question. It could be a question of fact, but you have to come forward with evidence to demonstrate that the decision maker did not make the decision based on the evidence before him, but rather for some other reason.
Correct. The district court never made any findings as to what the quote-unquote
It
decision
doesn't need to
maker
make
did.
findings. It's an absence of evidence.
It's not an absence of evidence when we...
Well, what's your evidence on pretext? That's what I've been trying to press you for.
The evidence is from the very beginning, long before even any of these hearings were noticed. Dr. Heligman and CSX sent a letter out to all these insurance providers and to the Railroad Retirement Board and said, this is evidence of fraud. So they had made their mind up from the get-go and actually accused them of fraud when Dr. Heligman said he had no evidence at that point.
Why don't you tell me what Brian, the decision maker, made? What did he know? What was he presented with?
He knew that because that was in the record in the investigation. Those letters were in the record, as were all of the COII forms, as was all the...
Do you see how that's not an argument of pretext? That's not an argument that they fired them for a different reason. That's just an argument that they made up their mind about this reason really early, right? That from day one, they thought there was fraud. And, you may think that the evidence didn't show that and that the, appellate board should have disagreed with that, but that's not proof that they didn't fire them for fraud. That's not an argument about pretext. That's an argument that, they came to a conclusion very early about this very same reason for firing them.
Well, the pretext comes into play when, and this is the Sears case that's cited, is the shifting explanations and the mistakes of fact, and that's replete throughout the record.
What's the shifting explanation? You said from day one, they sent letters out saying this is fraud, the employees are lying, and then Mr. Barr says I fired them because they were lying.
The shifting explanation is Dr. Heligman saying, I absolutely believe that
I didn't have proof they were lying, but I thought they were lying, right? That's what he said.
But that's a fact question for the jury.
No, it's not. That's not about pretext. That's about whether he was right. That's not the question for the jury. The question for the jury is, was that the reason they were fired?
Right, and well, there's numerous issues of pretext. That's one, for example, that he was claiming it was fraud when he knew it wasn't fraud, and the reason why he wanted to make it fraud was, just as was acknowledged here, they wanted to save on benefits. They didn't want to pay these employees benefits for a term of 2 years or a year or whatever it was, when they could get away with paying them for 4 months if they did
No
what
evidence
they
of
did.
that.
I'm sorry?
No evidence of that. But
The
anyway,
evidence-
I think your time is up. Why don't we hear from Mr. Paul?
Thank you, Your Honor. If I could just follow up on that. The evidence of the 2 years versus the 4 months is at JA 2163:5 through 2164.22, and it appellee's brief at page 7. That was their motivation for trying to get out and paying those extended benefits.
What's the evidence of that?
The evidence of how they benefited by...
Not how they benefited. What is the evidence the decision maker was trying to do that? In other words, the decision maker thought there was dishonesty here.
Right.
And the decision maker had a lot before him, and they had a whole process leading up to why they thought it was dishonesty. You can poke holes through that, but that doesn't go, they made the decision that these employees were dishonest and fired them. And so now the question is, did they fire them for dishonesty, or did they fire them for some other motive?
So what was before Mr. Barr and under the collective bargaining agreement is limited to the hearing transcript, any exhibits that were at the hearing transcript, and those exhibits like the charge letters and the letters that were sent accusing them of fraud. What changed is that conspiracy to engage in a fraud and the actual proof along the way that was a predetermined decision that Dr. Helligman made, and that was not justified.
Well, let's assume you're right, but they chose to follow that.
I think that brings us right to the honest
It's
belief.
there's no pretext. They didn't do it for some other reason. It's clearly they thought he was dishonest, and that was presented to the review board and all the other, from the get-go, there was a suspicion of dishonesty here because of the announcement of the furlough, and then the 16 or 17 application of taking leaves, and then it continued with the same people and all the same pattern. And they said, this is dishonest. That's what they concluded. Now, they may be wrong, but that's what they concluded.
Right.
And now your task is to say they didn't act on that. They acted on something else.
And the district court, applied that honest belief doctrine, which this court in footnote 2 of Sharif says not necessary.
Well, that's the interference claim. You're mixing up apples and oranges. I'm talking about the McDonnell-Douglas thing, the pretext. My question was basically, there's no evidence that I could see that this was pretext. That's where the district court concluded. Set aside the interference claim.
No, I know, but the court also applied the honest belief to the pretext claim, and I just want to set forth that that's not any kind of separate doctrine. I mean, honesty is on a spectrum of lying, and that falls under credibility, which goes to the McDonnell-Douglas. So there's no need for this honest belief. It's just falls within a credibility determination. Or, as I mentioned in the brief, some courts have found it to be a jury question, whether what someone believed or didn't believe. But what I think I hear Your Honor saying is that because they made a decision on day one of something they suspected, and we don't take issue with them charging them or investigating them in the first instance, but the fact that along the way, particularly without the benefit of the FMLA paperwork to substantiate that leave, was extremely harmful for them, because that would have established either whether it was or not medically necessary to take that leave of absence. And just to respond briefly, if I said this, I misspoke. I never meant to say that a second opinion under the FMLA regulations was required. Absolutely not. What's required is a healthcare certification from the employee's healthcare provider, and then the employer, if it has questions, has all these options, including a second opinion. So thank you very much.
Thank you. We'll adjourn court for the day and come down and greet counsel.